This is the Pilot's News Briefing Podcast. I'm Frank Daniels. With me today is Matt Lamb from the Pilot's Newsroom, bringing us the latest news in Moore County. And it's new, but it's more of the same, it seems like.
Here we go. We took a break last week from the comings and goings at the Moore County Courthouse, and we have an update. So we'll kind of start out with where we're at now and kind of give you a brief historical background of how this thing shakes out. But a defamation suit filed last month by incumbent Clerk of Superior Court Todd Maness against his Republican challenger, Deborah During, and District Court Judge Beth Tanner has kind of grown into a series of court filings that lay out accusations that involve several attorneys and senior resident Superior Court Judge Michael Stone. And that's kind of ended up as two show cause hearings. So following a request to move that underlying civil action, so Todd's suit, Maness' suit, out of Moore County, During and Tanner's attorneys, Mike Newman and Alicia Journey, received two show cause orders issued by Stone, forcing them to appear and defend their actions in the suit and basically prove that they're not in violation of professional misconduct. So this is a long-standing issue. In 2023, Tanner issued a show cause order to Maness, very similar kind of thing that's going on right now, to respond to some concerns about procedural shortfalls in the clerk's office. And there was a detailed attachment. She said there's problems primarily centered on administrative matters, court files, access, that kind of thing, assistant clerk, scheduling of cases.
And sorry, I mean, not to derail because this is probably going to be a long.
It is.
It's going to be a little bit of a long podcast, but the show cause order is kind of an internal court action, like a judge or another.
Yeah, and you basically say, hey, you're going to come before me and tell me why you aren't in the wrong and why we shouldn't punish you in some way.
Like,
they can hold you, you can censure you, you can hold you in contempt, you can make you go to continuing education classes, substance abuse classes, professional development, that kind of thing.
Okay, all right, sorry.
And 2 weeks after that, Maness sued Tanner and retired Superior Court Judge Jim Webb. And he said that those two were attempting to undermine his position and subvert and override the will of Moore County's voters. They wanted to have Maness removed from office. That was his contention. And it was ultimately dropped. And when it was dropped, Stone and Chief District Court Judge Don Creed entered this joint administrative order. And it was basically the rules of the road. Hey, this is the decorum for the courthouse. And this is the chain of command that you guys will follow. So 2 years after that, Maness has sued Tanner again, and this time wrote During in his election challenger in a new complaint. And he talks a lot about the matters from the previous lawsuit, but everything in this lawsuit kind of hinges on a series of text messages that Tanner sent to Stone, where she questions whether Maness followed the correct steps and timeline regarding the county's jury commission. And to kind of get you up to speed, and I know we've talked about it before, but the jury commission is a 3-person panel appointed to 2-year terms, and they compiled this master list of potential jurors. And there are 3 different individuals or bodies that select those 3 individuals, and it's Stone, Maness, and the County Board of Commissioners. And those current members in Moore County are Randy Hussey, Jim Peterson, and Dennis Holder. Stone ultimately told Tanner, according to the filings, that I'm not apprised of this situation, but I'm going to investigate. And so the new suit from Maness contends that Tanner ignored that chain of command outlined in the administrative order, and that it stipulates that Stone's investigation found Judge Tanner's allegations were completely false and without merit. It's important to keep in mind that in none of the filings do we see Stone's investigation. So there's no first-hand account of that investigation in any of the court filings. And then you have During, who's a deputy clerk in Chatham County, but she's running for Maness' seat. She attended a Moore Republican Women Forum recently, and she said that it's my understanding that there's been some issues with how jury selection is handled. It's 20 words, and we've got the recording online, to which Maness, through his attorney, Michael Porter, states defendant During knew these allegations were false, or at least should have known these allegations were false. She had the knowledge to allow her to easily verify the veracity of her allegations prior to making them, which she either failed to do or did do, and chose to defend the plaintiff either way. So then we get to the defendant's responses. So this is Journey and Newman. And as far as Tanner goes, Journey says that there's fundamental flaws that warrant dismissal in this case. The motion contends that there's just not enough legally sufficient facts, even if those facts were true, to show a violation. Regarding the messages, which, keep in mind, those are the crux of the complaint, she says they're not actionable. They raise legitimate concerns about jury commissioner procedures, and those are raised with the appropriate judicial authority, which is Judge Stone. Additionally, there's no malice involved, right? It was a good faith inquiry. And regarding the jury commission, there is a suggestion that at least one jury commissioner was not appointed in a timely manner per journey. And then we've got Newman. Newman gives this 24-hour grace period that's poignantly written. And let me read this to you because, again, I think this is important. Neither Deborah nor I have any desire to become further entangled in the dark and grotesque underbelly of local politics. In my opinion, this fiasco is an utter embarrassment for the entire Moore County Bar. It impugns the integrity of all honest judicial officers. It borders on the legally obscene. We want no part of it. That said, grotesque or not, I intend to do everything possible under the rules of professional responsibility to protect Deborah from this nonsense. My hope is that you will do the right thing and immediately dismiss your claim. If not, we will join the sludge and proceed accordingly. So he also files a motion to dismiss, and he says that During's comments aren't actually defamatory, and they don't really even mention Maness. So then on February 4th, there is a joint motion to change venue. And it's basically an effort by Journey and Newman to get the case heard in Johnston County. They talk about extensive media coverage, Stone's role as a witness, the ongoing issues between Maness and Tanner, and the fact that they are both on a March 3rd Republican primary ballot here in Moore County. And then Michael Porter, Maness's attorney, looks to block that effort. And he accuses Journey and Newman of judge shopping or venue shopping. He says, hey, Judge Stephen Stokes from Cumberland County is available to hear all these motions on March 9th. You don't need to leave Moore County. You don't need to go to Johnston County. And then there is a suggestion that they want to go to Johnston County because Tanner has kind of a long-standing relationship with Judge Locke, a Johnston County judge. So as this legal dispute unfolds between Maness, During, and Tanner, Newman and Journey find themselves roped into potential disciplinary action. So on February 11th, Stone orders the pair to court. And he has taken exception with their concerns that there's a conflict of interest between Maness, Stone, and the judicial district, which includes Moore and Hoke counties. And he goes on to say that their pleadings, and in quotes, impugn the integrity of the Moore County judiciary. And I'll continue that statement. The above statements appear to imply, at a minimum, impropriety, and at the most, corruption of multiple judicial officials in Moore County. The court would be derelict in its duties if these matters were not properly addressed in a show cause hearing. So Stone goes on to appoint Robert Buzzard. He's a senior member of the Harnett County Board to serve as the investigator and prosecutor in the matter. And he goes on to outline some potential consequences like we talked originally about show cause hearing. And he cites, citations for contempt, censure, suspension of privilege to practice law, additional continued learning classes, and then again, like I said before, substance abuse and mental health evaluations. And in response, Newman and Journey jointly file a series of motions. They file a supplemental change of venue motion, a motion to disqualify Stone, and a motion to dismiss that whole show cause. They basically say that, and this is where it gets kind of interesting, and it weaves in a lot of information from 2 years ago. They start to talk about the jury commission and some of the filings that are included in Porter's, some of his documentation. And it says that the jury commission officials were, and they use the term nunc pro tunc as proof that it was done incorrectly. And that's kind of a Latin term that says a court can correct an error or an omission, making an action effective at an earlier date. So it's like backdating. And so it says that based on the documents included in Porter's filings, that there are two different jury commissioners that are on board in October and November, but are backdated to July 1st. So in their mind, based on the documents provided by Porter, there is an issue with the jury commission. It's like prima facie evidence that there's an issue with it, right?
Yeah, seems You're right.
Yeah.
Abnormal.
Yeah. And so they go on to dispute the origins of the original judicial administrative order. So that's, mind you, Creed and Stone, who signed this administrative order that lays out the laws of the land.
In what, 2024?
Yeah, it would have been right after the turn of the year. And they say that the order was written and submitted by Porter, and they include this in exhibits. They have an example of Porter's letter, and it was sent to Christy Bennett. The email chain is included in exhibits. Sent to Christy Bennett, who's Stone's judicial assistant, and it didn't copy Tanner or her attorney or the appointed special prosecutor. And let me get into another quote here because I think it's worthwhile. Perhaps most concerning, the administrative order's entry directly affected the outcome of the criminal contempt proceeding against plaintiff Maness, initiated by defendant Tanner, which was pending at the time of Judge Stone's ex parte communication through Miss Bennett with plaintiff Maness's attorney. Mr. Porter, at the direction of Judge Stone, secretly drafted the instrument that terminated the contempt proceeding against plaintiff Maness without affording even the special prosecutor appointed to handle that proceeding any notice or opportunity to be heard. So they say also at the same time that Porter writes the administrative order for Stone, that Porter is serving as Stone's personal attorney in an unrelated matter in Cumberland County. They go on to say, as far as disqualification is concerned, that Judge Stone occupies three roles in this proceeding, and that is accuser, aggrieved party, and adjudicator, each of which independently requires his disqualification and which in combination constitute one of the most extreme due process violations in the history of North Carolina jurisprudence. As for the show cause, they say that, hey, all we have done is what attorneys do. You guys haven't said anything about criminal contempt or civil contempt, and that all we've done is filed pleadings, which is the mechanism that the rules of civil procedure provides for raising legal issues to the court. Again, they say that it's necessary for Stone to disqualify himself to the Administrative Office of Courts. Stone, however, doubles down and issues a second show cause hearing, claiming that based on those filings, he never presided over the matters at hand as it is. And I read this to you as well. It appears that Miss Journey and Mr. Newman, in multiple pleadings, and now in response to the first show cause order, have alleged nefarious conduct on the part of the court regarding the drafting of the court's own administrative order. He says that courts can enter administrative orders at will and that they can consult whoever it pleases, kind of vaguely referencing Porter without stating the name. And he says, hey, there's no duty to disclose regarding the administrative order because Tanner and Maness's initial lawsuit, it was already dismissed before the order was entered. He says, hey, look, I've got no jurisdiction in this case. And that administrative order, it just reinforced what was already going on at the courthouse. It laid out the rules of the road. It just codified it. He says, I had no intention of ever presiding over this underlying action between Maness, Tanner, and During. And as for his motion for disqualification, he says it appears to imply that the undersigned intends to preside over a case, the underlying action, in which he would be, in fact, a witness, referring to himself. If true, this court finds insulting. So he goes on to say that to him, it's obvious that Journey and Newman are making blatant attempts to judge shop and venue shop, and that these are serious ethics violations, and they impugn the integrity of the entire North Carolina judiciary and its ability to hold fair and impartial hearings. And he goes on to write, in quotes, the court would be derelict in its duties if these matters were not properly addressed in a show cause hearing. So as of now, as of our forthcoming print deadline, Journey and Newman are scheduled for a 10 a.m. hearing on March 9th in Superior Court. The same day, Maness, Tanner, and During are also scheduled to appear before Judge Stokes in the underlying case. So we certainly expect more to unfold, probably in short order, but I know that that's a long-winded locution to get us to where we are now, but there's a lot to it.
Right, there is a lot to it, and given the legal nature of this news, you're reporting, it's complicated by its very nature.
Absolutely.
And as you say, the newspaper that's coming out on this weekend, you've collected this information into your story for Sunday, and we're publishing this podcast on Friday.
Correct.
So I also anticipate that this will change in short order. So there might be updates to this information, but as of Friday, this is where this whole saga stands. And if you have questions, you can send those to Matt. And his email address is mlamb@thepilot.com. That's MLAMB@thepilot.com. You can send questions about the podcast to me, to frank@thepilot.com. That's FRANK@thepilot.com. And thanks for bearing with us on a long podcast on a Friday. Thanks, Matt.
See you, Frank.